Well, I really didn't think we'd have to do this 2 nights in a row, but the other side managed to escalate. So we're doing this again tonight. Ready? Let's go. Today, we're going to discuss the SEC's complaint filed against Coinbase in this escalating war being waged on crypto by the current administration and everything that might mean. If you were sad to see Coinbase getting dragged into this, but glad that we can now fight this all together, or if you're finding value in these videos each weekday, please consider delegating to the Army of Spies. Stake pool, ticker AOS. It really is unfortunate that we have to make 2 videos like this 2 days in a row back to back. But unfortunately, the SEC filed another complaint today, this time against Coinbase. The amazing thing is, this is working like some kind of occupation in World War II. We already have sympathizers coming out today within the Cardano ecosystem. We already have people coming out and saying, maybe Gary Gensler's not that bad a guy. Maybe he's just following the law. Maybe he's just doing his job as an employee of the SEC. That's not what's going on here. If that were the case, if he were just following the law, then we wouldn't have Hester Peirce, crypto mom, also a commissioner of the SEC, not the chairperson, but a commissioner of the SEC who completely disagrees. These are not black and white issues. This is a political agenda. The SEC has been weaponized, and the goal is to exterminate crypto, at least to cripple crypto, to suppress crypto. This is not a bureaucrat following the law. This is a weaponization of the SEC. He's choosing to do this because the goal is not to enforce the law. The goal is to exterminate crypto, at least to cripple crypto by shutting down its biggest fiat on and off ramps. This is not about a black and white interpretation of the law. This is a political choice to achieve a goal, which is to cripple crypto. That's what's going on here. This isn't about anybody, just sort of being forced to do these things because they're following the law. That's not what's going on. If that were the case, then there wouldn't be such extreme disagreement between a commissioner of the SEC and the chairperson of the SEC. And this SEC under this administration has seen significant turnover, the likes of which have been described with regret in front of Congress. It's like Congress is concerned about the amount of turnover in this SEC because this is an extreme course for the SEC to chart. And the reason it's so extreme is because it's not about enforcing the law. It's about achieving a goal of crippling crypto by shutting down its biggest fiat on and off ramps. So I guess it's predictable that we would have sympathizers when faced with an overwhelming adversary. Some people are always going to just sort of collapse and fall over and agree, instantly switch sides, instantly start thinking, actually, maybe the adversary is not so bad. It's like the aliens come down and, zap half your city. They incinerate half your city with a laser. You're going to have some people in the other half of the city welcoming their new overlords. There's always going to be some percentage of the population. So I guess I shouldn't be surprised, but I am surprised because I think I understand what's actually going on here. This is not black and white interpretation of the law. This is the weaponization of the SEC to achieve a certain political goal. So let's get to the actual complaint here. I guess this, we talked about this yesterday, the possibility that they would file on Coinbase next. I didn't expect it to be within 24 hours, but here we are. And, this sort of, very, very aggressive regulatory activity on the part of the SEC is pretty predictable. If you've been watching this channel, pretty much for the entire history of this channel, I've been saying that there were big securities law issues that crypto might have to confront. And especially if we got the wrong kind of administration in the White House that wanted to weaponize the SEC against crypto. And that's what we have here. Unfortunately, US crypto law is so broad. The definition of a security in the US is so broad and ambiguous that an agency like the SEC can be weaponized pretty easily if you want to call pretty much anything a security. So obviously the courts are the final arbiter of this, and we'll see what the courts do with all this. These are going to be long battles. This is going to be a war. This is going to be a long war fought over the very existence of crypto as an ongoing thing, an industry. Some people don't like it when you call crypto an industry, but we'll just use that as shorthand to describe the entire crypto ecosystem. And it might not be over. There's not really any reason to think that the SEC won't also file on Kraken. So Kraken already settled the staking issues with the SEC, but Kraken is also trading a bunch of these assets like ADA. It's maybe too much to assume that the SEC wouldn't turn around, even though they already settled with Kraken on the previous issue, they wouldn't turn around and also file sort of an identical complaint, a complaint just like this Coinbase complaint, minus the staking issues against Kraken. So the Binance complaint also included some other things, all of the issues around the wash trading and some of those types of issues. But aside from that, the Binance complaint and the Coinbase complaint share a lot of sections. There are a lot of sections that are word for word identical. And those same sections could also apply to Kraken. The SEC could turn around tomorrow or at any point in the future, file a very, very similar complaint against Kraken and just sort of change the name of the defendant, throughout the document, and voila, they could file that against Kraken. So we may see that soon too. And that wouldn't surprise me because this is not about technical application of the law. This is about making the law fit the path to a certain goal. And that goal is obviously to shut down the fiat on and off ramps, the biggest ones in the US, which are Coinbase, Binance, and Kraken. So unfortunately, this is also a coordinated action. This Coinbase complaint was coordinated along with something like 10 different state regulators who are also charging Coinbase with various things involving the staking program, and I think even some of the assets being traded in some cases. But you've got 10 state regulators coordinating with the SEC on this. The Coinbase complaint does present some hurdles for the SEC, given the history of Coinbase, though. The SEC alleges that Coinbase has acted as an illegal, unregistered securities exchange since 2019. But in April of 2021, the SEC approved Coinbase going public with a listing on NASDAQ. And in May of 2021, SEC Chairman Gary Gensler testified that the SEC didn't have authority from Congress to regulate crypto. And now, what do we see him doing? Not only regulating crypto, but regulating crypto by enforcement, the worst way to regulate. These are some conceptual fundamental problems for the SEC. And once again, of course, just like with Binance, we see the SEC trying to pick winners and losers and, fielding a list of what it calls crypto asset securities. Of course, again, including cryptos like Solana, ADA, Matic, Sand, Filecoin, and a few different ones. The list isn't exactly the same, but a very similar list here. So, like I said, big sections of the complaint are just Control-C, Control-V from the Binance complaint. They just sort of do a word replace, make everything say Coinbase instead of Binance. There you go. There's your complaint. So once again, we know that's the case because word for word, they made the exact same mistake, implying that, or straight up stating that IOHK is still owned by Hoskinson and Wood. Seems the SEC is not aware that Charles bought out his partner long ago. So keep in mind here that the SEC is not trying. I saw people asking questions today about why this cryptocurrency is not included here, why this one's included. The SEC isn't trying to lay down law, which is not their role anyway, but they're not trying to lay down even their own interpretation of the sort of definition of a security with this complaint. That's not the goal of this complaint. They sort of incidentally had to do that with these crypto assets. But they only did that because I believe what's happening here is they're just picking the assets that they think most efficiently will help them shut down the Coinbase fiat on-ramps and off-ramps. So we can talk later, more about why Ether wasn't included in this list, just like it wasn't yesterday. But I believe what they're doing here, they're not trying to give you, any kind of criteria to go by or lay out definitions of what are crypto securities and what are not crypto securities. They're just picking assets that they think will most efficiently get them to that finish line of shutting down Coinbase. That's what they're doing here. That's their goal. It's not about laying out the law. It's about achieving their goal. So they do state that's a non-exhaustive list. So of course they're being smart. They're leaving it open so that they can add more later. So they can add Ethereum to that list later. They're not trying to foreclose the possibility of them adding additional cryptocurrencies to that list. So just as in the Binance complaint, and this is also important for the future of any complaints against, involving Ether, just as in the Binance complaint, notice that a burn mechanism in Solana and Polygon is mentioned to imply evidence of an expectation of profits for purposes of Howey prong number 3. This is the expectation of profits prong. You have to ask the question here. So they talked about this both with Solana and Polygon, and they said things like, this marketed burning of Matic as part of the Polygon network's deflationary effect has led investors reasonably to view their purchase of Matic as having the potential for profit to the extent there's a built-in mechanism to decrease the supply and therefore increase the price of Matic. So Polygon obviously has a very similar burn mechanism to Ethereum. What is it? EIP 1559. It really looks, and a lot of people were commenting today that it really looks like the SEC is just laying the groundwork to eventually go after Ethereum here. They're saying, hey, expectation of profits is built in to your having a burn mechanism. So obviously something that doesn't exist in Cardano. So no surprise, the Coinbase staking program is included here since Coinbase previously received a Wells notice on their staking program, Coinbase Earn, I believe it's called, and we covered that on this channel. Note that Coinbase already had Sullivan and Cromwell, the law firm of Sullivan and Cromwell, submit a very detailed and well-reasoned response to the earlier Wells notice. In that response, Coinbase characterized the SEC argument as a novel and untested application of Howey. And here's what they mean by that. They say the same holds true for the staff's novel and untested application of Howey, a case brought under the Securities Act of 1933. Remember, we've got two different acts in securities law. We've got the Securities Act of 33, the 33 Act. We've got the 34 Act, which is the Securities Exchange Act. One of them, deals sort of broadly, we're going to simplify this here, but deals broadly with securities themselves, and the other one deals with securities exchanges, or at least they're aimed at those two things, even though there's a lot of crossover and all kinds of complication. So here's what they point out, though. So Howey was a case brought under the 33 Act, and the staff here is applying that to secondary market transactions necessary to sustain the unregistered exchange and broker-dealer charges under the 34 Act. So Howey was a 33 Act case, and here the SEC staff is applying Howey to secondary market transactions, which is not what the Howey case was about. We've covered the Howey case previously on this channel. Howey was not about secondary market transactions, but they're applying it to secondary market transactions in order to establish this charge of Coinbase being an unregistered exchange and broker-dealer under the 34 Act. So different type of market activity. It's not the primary market, it's the secondary market, and it's a completely different law. Howey was about the 33 Act. the SEC is trying to go after 34 Act charges here. And of course, Sullivan and Cromwell says a court should limit Howey to its original understanding, and in so doing will substantially cabin the commission's broad assertion of its authority in cases well beyond the digital asset industry. So Sullivan and Cromwell also noted that this is an unhealthy departure from the previous relationship between industry and the SEC. Obviously, what you want to see with regulators is regulators having a cooperative relationship with the industries they regulate. You want to see them, giving advice and direction and instruction to the industry, showing industry how not to violate regulations and statutes. That's not what's going on here. Instead, we're seeing regulation by enforcement, which is the opposite, where you give no direction, you give no clarity, you create ambiguity, maybe even intentionally, and then you come back and say, oh, by the way, even though we refuse to give you any advice whatsoever about how not to violate the regulations, we're now going to charge you with a violation of the regulations. So also in response to that previous Wells notice, Coinbase indicated that it will rely on the congressional testimony of the CFTC chair, Rostin Benham, I guess his name's probably Rostin Benham, that ETH is a commodity. So what we have here is the CFTC chair saying that Ethereum is a commodity. This jurisdictional fight, the fact that the CFTC is claiming that Ethereum is a commodity, this is yet another possible explanation of why the SEC has omitted Ethereum here. And people have a bunch of different theories about this. People say maybe it's about statutes of limitations. Maybe the SEC is fearful that the Ethereum ICO was too long ago and it extends too far in the past beyond the statutes of limitations for certain charges the SEC wants to go after or something like that. We have a lot of different explanations. Maybe, like we talked about yesterday, maybe it's about the speech and the emails. They don't want to get into all of those issues. There are a bunch of different theories, but another one could just be they're trying to avoid the jurisdictional fight with the CFTC. So it's interesting also to note here that the SEC doesn't really delve into the technical details of some of the prongs of Howey. So one of the prongs of Howey, the common enterprise prong number 2, gets kind of technical. It turns out we have different types of commonality when we're talking about common enterprise. So with some of the assets, they get into this. And you can see this here. This is in the flow section for the flow asset. They say this stated distribution of flow tied the fortunes of flow holders to each other and to the fortunes of the flow development team. And here, even though they don't say exactly what they're talking about, they're actually talking about horizontal and vertical commonality. So we're not going to go too far into the technical details of this, but I'm just going to give you a really quick primer of what this is all about. We've talked about this on the channel before. There is a split in the circuits. The U.S. federal courts are divided into circuits, and the circuits can have different opinions about things. They can take different stances on issues, and that's the case with some of these commonality issues. There's a split in the circuits over this common enterprise theme prong. So there are distinctions between horizontal and vertical commonality, and then there are sub-distinctions in vertical commonality between strict vertical commonality and broad vertical commonality. You don't need to remember those names. We're going to talk about them real quick. Don't worry, this isn't going to get too boring. So in horizontal commonality, the examination relates to the fortunes of individual investors being tied to those of other investors. So are the fortunes of the investors in this security, are they tied to each other? Then you've got broad vertical commonality, where we ask the question, are the fortunes of the investors tied to the efforts of the promoter? Then you've got strict vertical commonality. Are the fortunes of the investors tied to the fortunes of the promoter? So if the fortunes of the investors are tied to the efforts of the promoter, broad. If they're tied to the fortunes of the promoter, strict. So the SEC doesn't get into any of those details here. The SEC doesn't seem pressed to detail all this at all. But it could just be because they're thinking they can always just argue that token holders of an ecosystem, whether those token holders are the team, the promoter behind the ecosystem, or the regular retail investors, if they're holding tokens, if they're token holders, they're generally all holding the same token, which has a common price that flows up and down. So they could basically just say that the network is the common enterprise, and the fact that they're all holding the same coin ties their fortunes both horizontally and in terms of strict vertical commonality, because the fortunes of the team, the promoter, would even be tied to the fortunes of the retail investors. So Coinbase will likely argue, as they did in the Sullivan and Cromwell response that we talked about just a second ago, that the secondary market nature of their exchange alters the vertical and horizontal commonality calculus. In that previous response from Sullivan and Cromwell, they said there is also no common enterprise present in the secondary trading on Coinbase, which requires that there be either an enterprise common to the investor and the seller, promoter, or some third party, which is vertical commonality, or an enterprise common to a group of investors, horizontal commonality. Horizontal commonality does not exist here because secondary market purchasers never pool their investments together. Vertical commonality is also lacking for secondary market trading, particularly where the promoter's initial protocol development efforts are complete, because there is no direct relation between the success or failure of the promoter and that of his investors. So one thing you have to know about the way these complaints are written, and this kind of a response to a Wells notice, the way they're written, there are often authorities that you rely on, like this case and this case and this case, that make your position sound really good. The thing you have to remember, if you're not familiar with this, is that the other side might disagree about the authoritative value of these cases. They might say, hey, that case is not really on point here. It's not really as relevant here as you make it sound for the following reason. It's distinguished by the facts. The context in that case was slightly different, so this shouldn't have as much authoritative value. And a court might agree with the other side. So even if you read some legal writing, some persuasive legal writing, and there is a solid case that they're relying on there, you have to ask yourself what the authoritative value of that case is. And in order to do that, you have to look at the facts of that case, the context of that case, and everything about the case. Basically, that's what happens when a court goes through these various arguments. They have to decide, if the cases each side is relying on are actually of good authoritative value. So it's interesting to note here that their argument for lack of vertical commonality, we're just going to set aside those issues about the authoritativeness of these cases, but it's interesting to note here that their argument for lack of vertical commonality seems to apply especially to scenarios where initial protocol development efforts are complete. If you're familiar with crypto, in the world of crypto, it seems hard to say when initial development is ever complete. Like, at what point on the Cardano timeline was initial protocol development efforts complete? It's pretty hard to pinpoint that exactly. So, some people would say that initial protocol development is still not complete. So this is a pretty ambiguous sort of threshold to lay out there. Then we've got the investment of money argument. So in this Sullivan and Cromwell response again, they have something interesting as to secondary markets. They say, if the money isn't going to the promoter or the enterprise, do we really fulfill prong number one? So this is interesting in the context of Cardano, because you notice in both this complaint today and the one yesterday, and remember, the SEC had already seen this Sullivan and Cromwell response, as they were drafting, or even before they were drafting these two complaints they filed yesterday and today. And you have to think, as to Cardano, the SEC doesn't seem yet to be alleging any of the founding entities sold on any particular exchange, Coinbase or Binance. But the SEC does note sales of ADA by the founding entities. So there's a question here. So what Coinbase is saying, what Coinbase is arguing, is that if no money went to the project. Like if none of the secondary sales resulted in an investment of money that went to the actual project, then you don't fulfill prong number one of Howey. But the SEC talks about sales by the founding entities of Cardano. The reason they might be doing that is because they think during discovery they can establish that there were sales by the founding entities on Binance in the case of the Binance case, or on Coinbase in the case of the Coinbase case. So, of course, if such founding entity sales were made on those exchanges, then they would be easily discoverable during discovery if they haven't already been discovered during the investigation that led to the earlier Wells notice. We don't really know what happened during the investigation that led to the original Wells notice to Coinbase. Maybe the SEC's already asked Coinbase, hey, with respect to the following coins, were there any sells by the teams behind these coins on your exchange? And, Coinbase may have gone through their records and told the SEC, yes, here are those sells. So the SEC may already have all that kind of information that would be necessary to defeat this type of argument, like is expressed in the Sullivan and Cromwell response. So this is probably part of the impetus for the SEC complaint to mention sales by those founding entities of Cardano. In the case of Cardano, obviously they're going through, a different calculus with each of these assets. So where does this leave us? What have we got here? So we've got Binance in receipt of a complaint. We've got Coinbase in receipt of a complaint. Maybe we'll have Kraken with a complaint tomorrow. We don't know. Unfortunately, another Kraken complaint might not be the worst thing coming. Here's a little rumor. This post says, update, lots and lots of agency insider chatter that the DOJ is close next week to filing claims against Binance. The specific charges are not yet known. So this would be pretty bad for Binance and for CZ, because if we're talking about the DOJ, we're usually talking about criminal charges. So while the Kraken complaint from the SEC would be more civil charges for Kraken, this could be actual criminal charges from the DOJ as to Binance. And this account, I wouldn't say they've been 100% right about everything, but they've, a lot of the rumors this account is reported have kind of been in the right direction. They've kind of turned out to be in the direction of what actually ended up happening. Unfortunately, and I hate to say this, but I would not be at all surprised if the DOJ drags out some terrorist financing, some drug trafficking financing charges against Binance and CZ here. I would hate to see that happen, but unfortunately, the way this administration has weaponized agencies against administrations or against industries it doesn't like, I mean, this really is choke point 2.0. I would not be at all surprised if we saw the DOJ drag out some really extreme charges like that against Binance and maybe against CZ personally. I mean, if they're criminal charges, we might see some really heavy charges like that against CZ, which would be really unfortunate, but sadly, it wouldn't surprise me at all. Finally, here's a theory regarding what might actually be crypto's very best weapon in this war. This post says, if the SEC follows through on its threats to sue Coinbase, this was actually before they filed the Coinbase complaint, I believe the SEC will lose. The SEC's case has a fatal flaw, and the problem is entirely of Gary Gensler's own making. Let me explain. After he was confirmed to his post as chairman of the SEC, Gensler testified to Congress on May 6. So after he was confirmed to his post, he testified on May 6, 2021, that the SEC does not have authority from Congress to regulate crypto exchanges. You would think that the chair of the SEC would be a pretty good expert on the authority of the SEC. Of course, they wouldn't be a good expert if it seemed like they were trying to expand the authority of the SEC. But if even the chair of the SEC says, hey, we don't have authority to do X thing, you could take that as pretty authoritative as to what authority, no pun intended, the SEC actually has. I guess no redundancy intended. So This poster says the problem for the SEC is, of course, that Gensler's testimony was entirely correct. Which agency may be given authority to regulate crypto exchanges is a major question that can only be answered by Congress. The SEC can't simply wish its own legal authority into existence. And that is exactly how it works. Congress decides what legal powers an agency has. The agency might be able to promulgate regulations. They might be able to make little interpretations under that legal authority, but they cannot just grant themselves legal authority. This is probably the best weapon that crypto has in this entire battle. If Coinbase or Binance or both can convince a judge that the SEC actually doesn't have authority, doesn't have a legal authority, because it was never granted legal authority from Congress, then a judge might throw this all out. They might say, hey, SEC, we normally hear cases where you have filed a complaint against a corporation about something having to do with, like, the stocks issued by that corporation or other, established securities, but you've been granted, and that's an area where you've been granted legal authority by Congress, but this is not such an area. So it's possible that Coinbase or Binance could get these kinds of cases thrown out of court because they might be able to convince a judge that the SEC simply doesn't have any legal authority. And the great thing is, Binance has a gigantic war chest for litigation with the SEC. I don't think we really know what direction CZ is going to go with this. Who knows? I could see CZ being very practical and maybe, settling some part of this. It kind of looks like the SEC is not going to be a reasonable negotiation partner with Binance. It looks like, especially if the DOJ files charges. I don't think I think that kind of changes things, or I think they're going to be much tougher on Binance and CZ because of some of the things like the wash trading allegations and some of those kinds of things. With Binance, we know that Brian Armstrong and Paul Grewal are down to fight. They've made it very clear that they will fight this. All along, they've been saying, we will fight for crypto. Thank goodness. I hope they do fight for crypto, and I hope everybody in crypto gets behind them. I'm sure the entire Cardano community will get behind them because the SEC decided to name Cardano as a security in the suit. So I think everybody in Cardano is going to get behind Coinbase. I hope everybody in crypto gets behind both Coinbase and Binance on the assets as securities issues, at least. Obviously, it's going to be a different calculus on some of the wash trading allegations and some of those things. But I hope everybody in crypto gets behind both Coinbase and Binance on these issues about large crypto ecosystems, being, the assets of those communities being securities. This really might be existential for crypto. This might be that big battle that determines the future for all of crypto. Is it a future of totalitarian CBDCs? We've discussed in the past whether or not that's actually the future of CBDCs, but if we're given a choice between possibly totalitarian CBDCs and the world of free crypto that we currently enjoy, I think most of us are going to choose free crypto. I hope you're having a great week, and I'll talk to you tomorrow.